You are here today for an initial hearing on a petition to terminate the parent-child relationship, end quote. That petition was either filed by the Indiana Department of Child Services or by another individual or entity. The purpose of this video is to explain the termination of parental rights process, including key deadlines and your rights throughout the case. After watching this video, if you have any questions or if anything was unclear, please let the judge know when you appear in court. This termination petition may have been required to be filed by law. Termination petitions must be filed when you have not completed or have not benefited from reunification services and the time limits under law have expired. Federal law required the filing of a termination petition, or a previous termination petition was filed and dismissed, and 90 days or more have elapsed since dismissal. You are entitled to receive a copy of the petition to terminate the parent-child relationship. If you have not received a copy of the petition or need assistance in understanding the petition, be sure to inform the judge, and you will be provided a copy of the petition and the assistance of an interpreter to read the petition if you need that assistance. Because this petition has been filed, you are advised that you have certain rights, which I will now explain. You have the right to be represented by an attorney. You may hire your own attorney if you wish. If you do not have the money or means to hire an attorney, the court will appoint an attorney to represent you at no cost. If the court appointed you an attorney in the child in need of services proceeding, that attorney is not automatically assigned to this case. Must request an attorney be appointed to you in this separate case to terminate parental rights. You have the right to have a hearing on the petition called a fact-finding hearing. The fact-finding hearing must be commenced not more than 90 days after the petition is filed and must be completed not more than 180 days after the petition is filed unless there is good cause to go beyond these deadlines. Please note that the deadlines in termination cases generally cannot be waived or extended except in very limited circumstances defined by law. You have the right to receive notice of all hearings. You have the right to participate in all hearings to terminate your parent-child relationship. You have the right to confront and cross-examine any witnesses. That means that you have the right to hear the witnesses testify while under oath and question them. You have the right to present evidence and testimony on your own behalf, and the court will help you by issuing subpoenas to require witnesses to appear in court for you. This is a civil proceeding, not a criminal proceeding, but you have the right to remain silent regarding any criminal charges or acts. Anything you do say may be used against you in a criminal proceeding. Finally, you have the right to appeal any adverse decision against you to a higher court, which is the Court of Appeals, and you have the right to be represented by an attorney to appeal your case. The court will ask you if you understand the rights I've just explained. Please let the court know if you did not understand all or some of the rights I've just explained to you. Before the court can find that your parent-child relationship should be terminated, the petitioner must prove by clear and convincing evidence at the fact-finding hearing each of the following: that termination is in the best interest of your child, that there is a satisfactory plan for the care and treatment for your child, and that the additional circumstance alleged in the petition exists. It is important to understand what happens when a court terminates the parent-child relationship. If the court terminates your parent-child relationship, all your rights, powers, privileges, immunities, duties, and obligations, including any rights to custody, control, visitation, or support pertaining to the parent-child relationship, are permanently terminated. The judge will ask you to enter a response today. However, because you have the right to speak to an attorney first, it is important to know what responses are available to you. You can admit, deny, or remain silent. If you admit the allegations, then you need to understand that you waive all of the rights that I just explained to you, and you will be admitting that your right to parent your child will be terminated permanently. If you deny or remain silent on the record, then the matter will be set for the fact-finding hearing to take place at a later date. If the allegations made by the petitioner relate to a pending or possible criminal charge, that could be made against you, then you must understand that you have certain rights against self-incrimination before you make any admission. That means that you have the right to remain silent and you cannot be required to admit the allegations, give any testimony, or make any statement against yourself to anyone about the allegations. You also have the right to consult with an attorney before answering any questions about the allegations. In addition, anything you say about the allegations may be used against you. You should be aware of what could happen if you do not attend the trial. If you fail to appear at the trial in this matter, the court can proceed with the case without you present. Additionally, if one has not yet been appointed, the court will assign a guardian ad litem or a court-appointed special advocate to represent your child's best interest in this matter. Lastly, if you have any reason to believe that you qualify under federal law as an Indian child, please let the court know. This means that you are either a member or eligible to be a member of a Native American tribe or Alaskan Native village. If this applies to you, please notify the court when you appear before the judge. When you appear before the judge, you'll be asked if you understood the rights and advisements explained in this video. If anything was unclear, please inform the judge, who will provide you further explanation. You should direct any questions you have to your attorney as well if you have an attorney representing you. Thank you for your attention.